In this video, I will recap the key legislation that impacts employment. These 5 acts shown in the boxes are listed from earliest to most recent. They'll be covered in the summary format, indicating who they apply to, the provisions and compliance requirements. The website where the full act can be found is provided. Signed into law by President Richard M. Nixon on December 29, 1970, the Occupational Safety and Health Act created an administrative agency within the United States Department of Labor called the Occupational Safety and Health Administration, or OSHA. It created the National Institute of Occupational Safety and Health, NIOSH, which resides in the Centers for Disease and Control, CDC. According to the Occupational Safety and Health Act of 1970, it is responsible for each employer to provide a place of employment that is free from recognized hazards that are causing or likely to cause the death or serious physical harm to employees. The Act covers all employers and employees except self-employed persons, family farms where only family members work, workplaces already protected by other federal statutes, state and local government employers and employees to implement improved safety and health programs. The basic purposes of the Act are to reduce hazards in the workplace and to encourage employers and employees to implement improved safety and health programs. OSHA also requires employers to maintain reporting and record-keeping systems that monitor job-related injuries and illnesses. Regulations implementing this legislation have grown over time, and they are complex and detailed, so it's important that HR professionals understand the basics and how to obtain additional detailed information that applies to their particular employer and circumstance. Overall, the law holds employers accountable for providing a safe and healthy working environment. Posters are available for download from the OSHA website without charge. The law applies to all employers regardless of employee population size. OSHA requires employers to provide a workplace that is safe and healthy for employees, but they also must comply with established standards. The employer's responsibility can be categorized into 2 buckets shown in the left column and the center column. The left column is keep employees informed, and the middle column, keep employees safe. Employers have some rights as well, including the right to seek advice and consultation from OSHA and to be active in the industry activities involving health and safety issues. Employers may participate in the OSHA Standard Advisory Committee process in writing or giving testimony at hearings. Finally, employers may contact NIOSH for information about substances used in work processes to determine whether they are toxic. At times, employers may be unable to comply with OSHA standards because of the nature of specific operations. When this happens, they may apply to OSHA for temporary or permanent waivers to the standards along with proof that the protections developed by the organization meet or exceed those of OSHA standards. When OSHA was passed in 1970, employees were granted the basic right to a workplace with safe and healthy working conditions. The Act intended to encourage employers and employees to collaborate in reducing workplace hazards. Employees have the responsibility to comply with all OSHA standards and with safety and health procedures implemented by their employees. OSHA provides a general duty standard as shown here on the left. It requires employers to provide jobs and a workplace environment that are free from recognized safety and health hazards that could potentially cause death or serious physical harm. This standard also requires employers to comply with all OSHA rules and regulations and standards. Whenever possible, the Act encouraged OSHA to use previously existing federal standards or industry standards that already had substantial agreement in the industry. The resulting standards range from those that are job and industry specific to those that comply to businesses in many different industries. The more common standards are shown with the OSHA title and the number assigned to it in the Code of Federal Regulations for easy reference. While every attempt is made to keep employees safe, on occasion, an incident will occur, and OSHA requires employers to report incidents resulting in specific medical treatment within a specified time to be compliant. Starting with the top left corner, we can drill straight down the red path for the emergency route. A worker has been fatally injured and it needs to be reported to OSHA within 8 hours. If the incident wasn't fatal, we can follow the options across the top row and realize that the reporting requirement is then only 24 hours. If the incident is not one of these major items, we end up to the far right with no reporting requirement. OSHA regulations require that records be kept for many purposes. It's necessary to conduct and document inspections for the workplace, looking for safety and health hazards. It is necessary to document and make available to employees about hazardous materials and how they must be handled properly. Here are 3 main OSHA reports. Injury and Reporting Illness Report. It must include a record of each incident resulting in medical treatment other than first aid, loss of consciousness, restriction of work or movement, or transfer or termination of employment. Log or work-related injuries and illness. At the time there is a serious or fatal illness, a full incident report must be prepared by the employer and maintained in a safety file. These records must be maintained for a minimum of 5 years from the date of the incident. Summary of work-related injuries and illnesses. Employers with 10 or more people on the payroll must summarize all injury and illness instances and post that summary in a conspicuous place within the workplace. The report must remain posted from February the 1st to April 30th each year. Certain employers are exempt from some OSHA record-keeping requirements, and they are generally classified by industry standard classification, SIC code. Employers in the medical industry, construction industry, or manufacturing industry, or those under nuclear materials of any kind, have other requirements that must be met. Employees of financial services companies, banks, credit unions, stock brokerages, and investment firms have been the headlines during the recent years. They uncovered and disclosed misbehaving among other employees and were protected under the whistleblower provision of various laws. OSHA's Whistleblower Protection Program enforces the whistleblower provisions of more than 20 whistleblower statutes protecting employees from retaliation for reporting. Whistleblowers are protected from disciplinary action, termination, or other penalties. The Department of Labor is ultimately responsible for the enforcement. The Employment Retirement Income Security Act, ERISA, of 1974 was created by Congress to set standards for private pension and some group welfare programs such as medical and life insurance. ERISA regulates both pension and administration of employee welfare plans. Under this act, welfare benefit plans include any plan, fund, or program maintained by an employer for the purpose of providing any of the following: plan participants and their beneficiaries, medical, surgical, or hospital care, reimbursement in the event of accidents, disability, and or death, vacation and sick leave, unemployment benefits such as severance pay, apprenticeship and training programs, daycare, scholarship funds, prepaid legal services. For purposes of ERISA, a fiduciary is a person, corporation, or legal entity that holds property or assets on behalf or in trust for the pension fund. ERISA requires fiduciaries to operate pension funds in the best interest of the participants and their beneficiaries at the lowest possible cost to them. All actions taken with regard to the plan assets must be in accordance with the prudent person standard of common care, a common law concept that requires all actions taken with regard to the plan assets must be in accordance with the prudent person standard of care, a common law concept that requires all actions to be undertaken with the care, skill, prudence, and diligence that a prudent man acting in the like capacity would use. As defined by ERISA itself, fiduciaries may be held personally liable for losses to the plan resulting from any breach of fiduciary responsibility that they commit and may be required to make restitution for the losses and be subject to legal action. ERISA specifically prohibits transactions between the pension plans and parties in interest. ERISA sets the minimum standards for most voluntary established retirement and health plans in the private industry to provide protection for individuals. Under employee participation in the retirement plan, employees are required to complete 1 year of service or reach the age of 21, whichever is later. The plan will provide for 100% vesting after 2 years of service and then requires 2 years of service or age 21, whichever is later. Employees may not be excluded on the basis of reaching a specific age. Participation must begin no later than the first day of the plan year after meeting requirements or 6 months after requirements are met, whichever is earlier. These are the minimum requirements. For the vesting schedules for CLIF ungraded schedules, employees are always 100% vested in their own contributions. ECRA sets vesting schedules for the employer contributions. ERISA also provides for employer minimum standards, which falls into 3 categories. The benefit accrual is determined by the amount of entitlement for an accrued benefit. The plan must account for employee and employer contributions separately. Employees are entitled to all of their contributions upon separation. The form and payment of the benefit. Upon retirement age or leaving the company, and provide guidance for quadros. Form and payment of benefits. Employees can be paid out upon retirement age, leaving the company, and then dependent on the guidance for quadros. Alternate payees must be a spouse, former spouse, child or dependent, or a plan participant. Funding requirements. This is determined by an enrolled actuary. It precludes the employer from commingling funds with the business operating funds. Deposit must be made on a quarterly basis. The final contribution should be no later than 8.5 months after the end of the plan year. This table shows the distribution of required ERISA reports to the various stakeholders. A summary plan description provides plan participants with information about provisions, policies, and rules established by the plan and advises them on actions they can take in utilizing the plan. Annual report. ERISA requires annual reports to be filed for all employee benefit plans. The reports must include financial statements, the number of employees in the plan, and the names and addresses of plan fiduciaries. Participants may request a report of the total benefits accrued on their behalf along with the amount of the benefit that is non-forfeitable. If there is no non-forfeitable amount accrued at the time of the report requested, the earliest date that benefits will become non-forfeitable must be provided. Participants are entitled to receive a report no more than once per calendar year. The Uniform Guidelines on Employee Selection Procedures of 1978, or the Uniform Guidelines, are used by the EEOC, the Department of Labor, Office of the Federal Contract Compliance Program, the Department of Justice, and the United States Office of Personnel Management. These guidelines attempt to explain how an employer should deal with hiring, retention, promotion, transfer, demotion, dismissal, and referral. Under the uniform guidelines, if sued, employers can choose one of two routes to prove they are not illegally discriminating against employees: no disparate or adverse impact, and job-related validity. The Equal Employment Opportunity Commission, EEOC, defines the 4/5 rule as a selection rate for any race, sex, or ethnic group which is less than 4/5 of the rate for the group with the highest rate, will generally be regarded by the federal enforcement agencies as evidence of adverse impact. When adverse impact exists, employers are expected to either show that the selection process is valid, related to job performance, or stop using it and find an alternative process that has a less discriminatory impact. The purpose of the Immigration Reform and Control Act, IRCA, of 1986 is to reduce the number of illegal immigrants coming into the United States for employment. The Act prohibits employers from hiring illegal immigrants and is the first law to require new employees to prove their identity and their right to work in the United States. Regulations implementing this law created Form I-9, which must be completed by each new employee and the employer. The law prohibits discrimination against job applicants on the basis of national origin or citizenship. It establishes penalties for employers who hire illegal aliens. The Worker Adjustment Retraining Notification Act, WARN, of 1988 requires companies to give 60 days advance notice of plant closings or layoffs that affect a large number of workers. This notice must be provided to affected workers or their union representatives and to state and local authorities. This law helps workers who are scheduled to lose their jobs know in advance about the pending layoffs so they can begin making alternative plans. Employers with 100 or more employees are generally covered by WARN. Employees who have worked fewer than 6 months of the previous 12 and employees who have averaged less than 20 hours per week are not included in this count, nor are they counted in determining the number involved in the layoff. Private employers, both for-profit and nonprofit, are covered, as are some of the commercial public entities. Federal, state, and local governments are not covered. An employer who violates the WARN provisions by failing to provide appropriate notice to a plant closing or a mass layoff must pay each affected employee back pay and benefits for the period of the violation up to 60 days. The employer's liability may be reduced by wages during the period of the violation and other payments made to the employee. An employer who fails to provide notice as required to the local government is subject to a civil penalty not to exceed $500 for each violation. The penalty may be avoided if the employer satisfies the liability to each employee within 3 weeks after the closing or layoff is ordered by the employer.